despite plaintiffs' groups wanting the state to ultimately have a stay on a lawsuit against the gun and magazine ban, you've got a judge saying, no, we're not gonna delay this. Welcome back, Bishop on Air. I'm Greg Bishop. Thanks for hanging out with us each and every weekday morning. Talked with Thomas Maag. He is an attorney for the Langley plaintiffs in the case challenging the state's gun and magazine ban, and he gave us a little bit of an overview of what happened on Friday in a scheduling conference. And if you saw the show on late Friday, I did do an update just to let you know how that case played out. And if you follow me on Twitter, you can see that as well. But ultimately, the headline is, Judge denies delaying case on merits of Illinois' gun ban challenge. And what had happened was the judge called the case to order, and then proceeded to ask the various plaintiffs groups what they're dealing with, and what kind of witnesses they're going to have, what kind of expert testimony they're going to have. And then the plaintiffs groups essentially said, hey, we actually want to hold off on the merits so we can ask the U.S. Supreme Court to intervene again. And the judge said, not going to happen. He said that they're going to move forward with this and focus on the merits. I connected with attorney Thomas Maag, who is one of the plaintiffs group's attorneys, who said that they don't want to hold off on this and they do want to get to the merits on all of this. Here's Thomas Maag from a conversation I had with him on Friday with an overview of what transpired in that scheduling conference.
What happened today is there's a scheduling conference in the assault weapons ban case in Southern District of Illinois in front of Judge McGlynn. Judge McGlynn, from my perspective, made it clear that it was his desire to get to the merits of the case and to get the case rolling on other than just preliminary matters. The case has largely been tied up for a year plus on what he called, and I agree with him, preliminary matters. It sounded like the state and several of the plaintiffs' lawyers wanted to delay the case further. The judge was having none of that, and I agree with the court that the case needs to proceed. The court has directed the parties to confer amongst themselves and has reset a status date in about 3 weeks, with the clear expectation that the parties will come up with a discovery schedule for a trial on the merits.
And if I recall, if you watched on Twitter as I posted live updates of that scheduling conference, the next status hearing is going to be February 2nd. But you do have before then the state having to respond to Maag's Fifth Amendment argument claim. And that's coming up January 19th. So just in a handful of days here, we'll have the state's response to Maag's challenge on the Fifth Amendment grounds. But what all is going to be debated on the merits here? Maag laying out his expectations after Friday's scheduling conference.
It sounded to me like the judge thought he would probably be ruling before the evidentiary hearing on the Fifth Amendment issues, but it sounded like any issues that are before the court will be tried at the evidentiary hearing to the extent that they haven't been decided already.
So the judge, Stephen McGlynn, in this case on Friday, he said that he's not going to delay. He's going to move forward expeditiously and wanted to look at each individual firearm as to whether it's banned or not. And Maag kind of illustrating some of what that could look like moving forward.
For instance, the Seventh Circuit made note that pocket pistols are clearly protected by the Second Amendment, but the pistol that I carried before the ban, a .22 caliber Beretta, is banned by PICA. So if per the Seventh Circuit, pocket pistols are allowed to be owned and carried, why can't I carry my Beretta .22 pistol just because it has a threaded barrel? That's absurd. Granted that there might conceivably be something that's banned, I'm not sure what, that might not be protected by the Second Amendment. And I think it's very clear that the court wants to go through the list, and are pistol grips banned? Are collapsing stocks banned? Are threaded barrels banned? That's my reading of it, and I think that's appropriate. Let's get a ruling on each individual item, and we'll know what's constitutional, what's not. And I think most of this statute will ultimately fall.
And the judge Friday telling the plaintiffs that they need to move forward on this because people are being irreparably harmed, allegedly, and they need to get to that quicker than later. But you had the plaintiffs groups, except for Maag, that were saying that they want to hold off on moving forward so that they can judiciously get the Supreme Court of the United States to review the case, despite the Supreme Court having already denied reviewing the case without the full record being on the table. You've had multiple instances of that being requested, at least by the Beavis plaintiffs out of the Northern District of Illinois. But down in the Southern District of Illinois, Judge McGlynn saying he's moving forward with this, especially after the mandate issued from the Seventh Circuit Court of Appeals on those preliminary measures that the Seventh Circuit Court of Appeals said the state was likely to succeed on the merits. So now it's time for the merits to be debated. But just because you file a request to the U.S. Supreme Court doesn't mean that the U.S. Supreme Court's going to take that case, and that's why Maag says they have to move forward with this.
Absolutely. I mean, the plaintiffs groups, as I understand it, all of them intend to, including myself, intend to file a petition for a writ of certiorari in the Supreme Court. But unless and until the U.S. Supreme Court grants the appeal, called a writ of certiorari, we've got to proceed, and it doesn't change what's going on the ground. Most cases never make it to the U.S. Supreme Court. Yes, this case has a better than usual average or better than usual chance of getting there, but that doesn't change the fact we've got to make this case go forward. And in the event the Supreme Court doesn't take it, we've got to prepare a record and prepare a trial and prove our case in accordance with what we believe the law is.
Again, something else that the judge noted was that all of the preliminary actions in this case have lasted a year and hasn't really moved things forward. And now that those preliminary actions, we see the indication the Seventh Circuit Court of Appeals is taking, then you've got the merits that need to be dealt with. And the judge even saying that people allegedly are being irreparably harmed, and that's something that Maag reiterated.
Right now, as I understand it, there were about 28,000 people total in the state of Illinois who have registered something. There are 2.4 million FOID card holders, as I understand it, in the state of Illinois. The bottom line is this. That means there are millions of people in the state of Illinois that right now are in violation of the PICA statute. Whether those are felony violations or misdemeanor violations might depend, but our governor and the legislature have made felons out of millions of Illinois citizens. And that needs to be addressed sooner rather than later.
But just how soon will the evidentiary hearings move forward? We'll be watching that closely in the weeks ahead, but Maag has some predictions on the trajectory of the case and the timeline.
It was clear from what Judge McGlynn said that he said the lawyers should not plan on missing any breaks over the summer. Sounds to me like that the judge wants to have a trial on the merits before June.
So a trial on the merits before June. A year and a half after the Protect Illinois Communities Act was put into effect, banning all sales of certain semi-automatic firearms and magazines and attachments over certain capacities and so on. But there's also that registry where you have around, 30,000 people telling Illinois State Police they have a banned item. Well, we'll watch that closely, but we'll also look at what the Joint Committee on Administrative Rules does today. They do meet in Springfield, and you have the second notice rules from Illinois State Police for the gun registry where the deadline was 16 days ago. So will the second notice rules clarify some things? We've already gone through some of that, but we'll review ultimately what the Joint Committee on Administrative Rules does today on this issue. So stay tuned. A lot more coming up with Bishop on Air each and every weekday morning. Appreciate you guys hanging out with me. All right, like, subscribe, hit that notification bell, buy some merchandise, support the show. Just hanging out with you in my home office before I head off and watch what happens at the Illinois State House.